paperwork ready, and then we'll start off with Mr. McCormally doing a sound check, and then we'll do the same for Mr. Thompson, then Mr. Thompson can begin his argument.
Sound check.
Thank you, Counsel.
Yes, thanks.
Mr. Thompson, you can do the same and then go on into your argument.
Test, test.
Thank you. Yep, thank you.
Thank you, Counsel.
Thank you, Chief Justice. May it please the court. Counsel. On December 12th, 2019, the Auditor of State sent an email to a single member of a state board asking about information related to a financial transaction that was planned for the following March. That exchange led to further discussion and ultimately to a subpoena seeking a wide array of information related to this transaction that still had yet to occur. This appeal arises from a district court order enforcing in part that subpoena. Without question,
Mr. Thompson, that you're kind of jumping into one question that I have. When I think of the concept of an audit, usually it's something that's already happened, not something that hasn't happened yet. You're not arguing that they lack authority that Mr. Sand and his office lack authority to audit a transaction that hasn't happened yet, are you?
well, I think the fact that it hasn't happened yet is one of the facts that you look at in this record to really determine that the district court abused its discretion when it concluded that the auditor was doing the fiscal 2020 audit. I mean, so to your question, not only had the transaction not occurred, the fiscal year had not ended, and it's undisputed that the audit for fiscal year 2019 was still ongoing. And so it's in that context then that we view this record, this exchange, and frankly, our position is when taken as a whole, the record cannot support the conclusion that the fiscal 2020 audit was what this was about, and therefore this court should reverse. Based on the documentary evidence, the affidavit evidence, and even statements of counsel in the hearings and the briefs about what their position is. What the agency was faced with, as you have, the record isn't long, but was with a moving target. And it's the position of the agency, and the reason we're here to get an answer from you is that an audit has to be a thing because the statute otherwise doesn't mean anything. And it has to have a beginning and an end. And then it has to have a subject, a purpose, because even if you look at the legal standards that you would apply in order to evaluate the validity of an administrative subpoena, you would look at the statutory authorization as a key thing, but you'd also look at whether the request was reasonably related to the purpose of the investigation. Without a beginning and without an answer as to what this audit is about, it's impossible
Mr. Thompson, let's assume that the transaction had been completed and independent of the fiscal year audit, the auditor just said, I'm interested in auditing this particular transaction or conducting an examination of this particular transaction within the meaning of the code. Would that have been permissible?
Yes.
So this is a timing issue from your view?
It's timing, and also it's a substantive issue. So the judge at the district court level asked counsel that very question. Counsel says, no, this is not an examination, this is an audit. And then later, as we get into the hearing, ultimately they said it wasn't the annual audit anyway. And so we've got, again, and the court pointed out that I conceded that same thing in the district court. I've also conceded that if this were in fact part of the 2020 fiscal audit, that would be subject to these statutory requirements, because it's a two-way requirement. In other words, this broad power to get access to information, including confidential information, is connected to the requirement that there's an authorized audit.
Yeah, but this whole thing started with your client going to the auditor and saying, hey, we got this thing cooking.
Correct.
And so then, not surprisingly, probably one of the biggest financial deals ever in the state, the auditor turns around and says, I got a few more questions for you.
That's true.
And isn't it possible for one fiscal year audit to perhaps overlap a bit with another?
It is.
And so in this situation, why, if we would accept your argument, why wouldn't all state agencies orchestrate transactions to keep the auditor out of their biz? I mean,
Number one, factually, that's not what happened here. And number two is, again, if you look at the record, once the subpoena was issued and an audit was specifically identified, the agency immediately responded, said, let's have a meeting, and then responded with a letter that says, here's all the publicly available information we have and the additional information that you're seeking, which is what starts this on December 12th. Specific questions about investors, we will provide that information as soon as it is available. So one of the issues here is, just like other agencies, this particular agency has both statutory and contractual confidentiality obligations. And in this complicated transaction, there were confidential pieces of information that, if disclosed, could have created liability and a problem for the transaction.
Counsel.
And so the important, I'm sorry.
Counsel, sorry, under Code Section 11.2, sub 1, it says the auditor of state shall annually and more often, if deemed necessary, audit the state and departments.
Yes.
Is it permissible, or would it be permissible for the auditor here to deem it necessary to audit this particular transaction?
Yes. I mean, we're not saying they can't do that. So the factual record, I think, establishes, A, that's not what they did. And number two is, this transaction had not occurred yet, and much of the information that they were seeking literally didn't exist yet. There were no investors who had been selected by the private partner here.
but the briefing talks about your exact percentage of 21.2 or something like that of these people are Iowa investors. So you got to know something more than just a general. I guess my concern or my question has to do with if it, no matter if it's called an evaluation or an audit or whatever, if it was during this fiscal year or that fiscal year, it seems to be undisputed that they're entitled to it. Am I correct that you're kind of holding back because of confidentiality?
That's part of it.
And wouldn't the statute already, I mean, you can let go of that and they're already, if they mess up the confidentiality, they're on the hook.
That is true. So the reason we need the court's answer to when this begins and what it is because, I mean, I don't mean to pose a question to the court, but on December 12th, when Auditor Sand sent that email to a single member of the board, would they have been safe in producing confidential information to the auditor and knowing that that would have been protected under the other provisions of the statute or not? And that uncertainty is what drives the decision for them
Am I reading the law correct? Am I reading the law correctly that obviously the auditor is entitled to information regardless of its confidential status?
Correct.
When the auditor then issues his or if it's someone else, her, if it's a woman occupying the office, in this case, his report, they're entitled to make public that confidential information if it's part of their report? Is
They
that
can.
right?
Correct.
So that's the underlying concern. Is that what you're talking about as far as confidentiality?
Well, they can make it, so two things. The confidentiality provision has two components. One is in 1141, and it talks about access to all the information all the time, but the auditor, in doing an audit or an examination, takes on the confidentiality obligations of the providing agency. That's the first part. The second part is a bit broader. It says that all the information gathered by the auditor, including allegations of fraud or abuse, must be kept confidential until such time as it's necessary for a report. And so,
One, right? Not just your client. in this case. I mean,
That is absolutely.
and if everybody would hold back and require, I mean, I can see everybody wanting to hold back. Nobody likes the idea that that confidential document's handed over. But are you the one who gets to decide whether you even hand it over?
Well, no. And so, and to be clear, I mean, my client in this case absolutely takes seriously their obligation to transparency and accountability, but is also concerned about obligations and the potential risks associated with disclosure of confidential information.
So, but don't those risks and concerns go away when there's an order enforcing a subpoena
Yes,
and a declaration that there's an audit?
yes.
So I understand your client's concern about confidentiality, but at this point, it seems like their duty of being transparent and complying with the statute resolves that, right? I
Well,
mean, right,
and
they have cover, so to speak.
Absolutely.
Okay.
And so, I mean, one of the questions that I thought one of you would ask me is, well, then why isn't this just a moot issue? And the question is, I think this factual record illustrates that, yeah, once you have a subpoena in hand that says, yes, we're doing an audit, and the auditor says, give me confidential information, then the risk shifts from agency to auditor, but it's still risk that the state has, and a disclosure could cause issues related to that. And so part of it is trying to get guidance from this court about what is it that triggers the two things that we're talking about. None is the absolute undisputed obligation to cooperate and give information to the state auditor to help him do his job, him or her. But the mirror image obligation that is built into this statutory scheme is the understanding and obligation to not make public statements and to keep it confidential until you issue a report that deals with the subject of the audit. So we need to
But
know.
why is that a concern of your client? Your client's statutory duty is to comply and provide the information. Now, whether or not your client believes that the auditor has too many press conferences and does too many reports and leaks information is not a statutory ground to fail to give information.
I totally agree with you, Your Honor. All I'm saying is, if you go back in the timeline, and so your example is, so once the subpoena was issued, what problem do they have? It gives client cover. I totally agree with you. But back up in this chain of the timeline and go back to December 2nd when a board member gets a request from the state auditor, and then read the briefs. I mean, the position that's being taken is if the auditor asks for any information at any time, we should assume he's doing an audit.
Mr. Thompson, I've been told that you need to be closer to the mic so they can pick you up.
I apologize.
That's all right, your words aren't
tend to
getting
do that.
recorded.
But I mean, I think that's the point, is there's a point at which the duties and responsibilities are clear. The question is, when does it begin? And we've tried, at least in the context of the audit that was asserted to be the audit in play, which was the annual fiscal year audit for the University of Iowa, provide evidence in the record about what that these parties have been doing it for decades.
Yeah, but that's an annual one. Isn't it possible that there's more than one audit going on at a time?
There is, but that's what they said they were doing.
Subpoena, I'm looking at the subpoena on page 49 of the appendix. It's directed to the Board of Regents, which I need to segue for a moment. The brief of the auditor's brief talks quite a bit about the fact that, hey, we subpoenaed who we were told to talk to. And you're saying they subpoenaed the wrong person? Am I correct? Or the wrong entity?
No, that's not the argument we've made. What we've argued is there was a significant exchange of information. There was information offered. As you know, if you follow the chain, they talked to one person, they talked to other people, they issued a subpoena to a specific entity for a lot of it. I mean, if you look at the subpoena, it's an exhausting, and some of that information was not information that the board had. And so the district court actually limited the subpoena and said that you can't order them to produce what doesn't exist or what they don't have. So we're not, I mean, they subpoenaed somebody who had information. The complaint that got raised and that we've talked about is that some of the information that they sought in the subpoena wasn't available from the party that they.
One more question I wanted to ask, then I'm going to hand it over to Justice Waterman. I could tell he wanted to ask a question. And in that same subpoena, because you mentioned earlier something about if it was subject to an audit, we just want to make sure that we're covered. It says right in the form document to present certain documents relative to an audit. Isn't that written in big crayons? You know that it's going to.
It is. And so with audit in hand or with subpoena in hand, there's clarity about that. But again, we're here because even in the hearing, they said this is not about the annual audit. This isn't the normal annual audit. The evidence is that annual audit hasn't begun. And so the factual record here creates doubt in the mind of the recipient and of the person trying to decide what they need to do to comply. And the lack of clarity and the confusing signals puts an agency in a position of trying to understand what their legal obligations are. They are willing to comply. In fact, they have complied. But at this point, what we're asking the court to clarify is this idea that an email to an individual board member is enough notice to begin an audit. If it's true, then tell us that, and then as the court has talked about, that then gives the agency protection from issues related to confidential information. I'm out of time, and so
Trying to ask a question, I kept cutting him off.
I mean, you brought up mootness, it beat me to it. What happened in December 2019 seems like old news. The transaction has closed now, right?
Correct.
And you've already complied with the subpoena as ordered?
Well, if you look at the letters, the instructions were work with the state auditor's representative at the University of Iowa once, and that would be done in the context of the 2020 fiscal year audit. They haven't started working on that part of the audit yet. So, but we're prepared.
Still in progress, but if we agree with you that this was not really the 2020 audit, does that require us to reverse the order enforcing the subpoena if they could have done it as an interim audit or an examination?
I don't think so, but I think that again, the issue is when do these serious, important statutory obligations attach so that agencies know how to order their affairs to comply with the law? And so that's why I think it's not moot.
It's
That's all I have.
issue of public importance likely to recur and evade
Evading
appellate
review. Indeed.
Okay.
Thank you.
Jim McCormally?
Thank you, Madam Chief Justice, and may it please the court. The plain language of the statute. Some years ago, I was in this chamber and I began an argument by saying the plain language of the statute, and I went on until my red light went off, and as I was leaving, one of the justices said from the bench, "You had me at plain language." And I was appreciative of that, but it occurred to me
I
that,
remember the case, and that might have been Waterman.
but it occurred to me that maybe I could have taken the suggestion to be briefer. And so I will endeavor to do that today because I'm faced with the same argument. The court's different, the issue's different, but I'm still starting with the plain language of Iowa Code Chapter 11. The auditor is granted access at all times to all information used by the entities that it's auditing.
Here's where I am a little bit concerned about sort of the breadth of the argument you raise in your brief. I mean, you basically say that the auditor is entitled to any information in the possession of any state agency at any time. Is that fair?
That's correct.
What would prevent, say, a different occupant of this office that's currently being occupied by Mr. Sand from saying, well, I'd like to see what the professors at the University of Iowa are doing these days. I'd like to subpoena their teaching records and their teaching files, and I'm going to audit them. I mean,
Sure.
what would prevent that under the broad, assertion of authority that you've made here?
Under Iowa Code Chapter 1141, nothing. Under resource constraints and time restraints and the applicability of using that information in a report, I think, practically speaking, there would be constraints against doing it.
So counsel, under section 11.19, it refers to an authorized audit. Are you saying that there's no such thing as an unauthorized audit of a state department?
Of a state government agency, absolutely. That is what 11.2 says in its plain text. The auditor of the state shall audit annually, and more often if deemed necessary. And I want to address something that Mr. Thompson keeps referring to, which is this distinction between the audit, the annual financial statement audit of the university, and other audits. Mr. Sand, in one of his emails to the university, said bid testing and internal controls are part of a normal financial audit. That is straight out of the Yellow Book. But the Yellow Book defines two different categories of financial audits. One is the audit of a financial statement, which the auditor's office does for every state agency every year and compiles them into the certified annual financial report and the single audit and all these things that I didn't know about before I came over to the auditor's office. But the other thing that Chapter 11 charges the auditor with doing is reporting on unbusinesslike activities, illegal activities. Are the taxpayers getting the most efficient use of their money that they're supposed to? The things that the auditor is supposed to report on are laid out in Chapter 11.4. And so with a state government entity, the auditor is authorized to look at any information he deems necessary to fulfill that statutory duty. The authorization piece, Justice McDermott, comes into play when we're talking about governmental subdivisions, which is the other big broad category of the auditor's duties. And that's Chapter 11.6, which involves the audits of counties and cities. And the important distinction is those entities they can go out and hire a CPA firm to perform their annual exam and audit. They can also come to the auditor of state for procedures if they choose to hire the auditor instead. But for a state government agency, the auditor is a